And welcome to our first webinar of 2023. I hope everybody missed us in December, but we are back. So thank you for joining us today. Some quick housekeeping as always. The session is being recorded and you'll be able to find a copy of it on our website afterwards to schedule on demand at any time. We have 25 minutes for today's session, a lot of content we want to cover. So if you have any questions, please use the Zoom functionality chat, which you'll find right at the bottom of the screen. Submit any questions to the panelists, and any we don't get today, we promise we will follow up with afterwards. But we do have a lot of content to do today, and we have Dr. Tyler Mell, our Chief Health and Strategy Officer at MediKeeper, to steer the conversation for us, and he does have a very special guest for us. So Tyler, we are looking forward to the session.
Thank you very much, Daryl, and good morning, everyone. We really appreciate you taking time out of your busy schedule to join us here today. So we're focusing in on workplace wellness and the law. Very exciting topic, something I've been looking forward to for a while now. From an affiliation and disclosure perspective, I'm the Chief Health and Strategy Officer at MediKeeper, as Daryl mentioned. I also sit on faculty at Pacific Coast University for Workplace Health Sciences, and I'm a board member for the National Wellness Institute, as well as the Work Wellness Institute, as well as a few other organizations that I'm affiliated with. And I happen to have a colleague and friend, Barbara Zabawa, today, who actually shares a very similar pedigree. So, Barbara, would you like to introduce yourself?
Yes, thank you, Tyler. Hi, everyone. I'm Barbara Zabawa, and I am an attorney. I own the Center for Health and Wellness Law, or I've just renamed it actually to Wellness Law. And I'm also clinical assistant professor at the University of Wisconsin-Milwaukee, and on the board of directors for the National Wellness Institute. I've been practicing law for over 20 years, and I started my law firm, Wellness Law, over 8 years ago, and it's been quite a joyful experience, and I'm looking forward to our conversation today.
Excellent. Thank you very much, Barbara. I really appreciate you being here. As is customary in our webinars, this is a roadmap for what's coming down next. Historically, back in November, I did a few sessions for the International Foundation of Employee Benefit Plans, did a healthy aging workshop, so what employers can do now to help people whenever they transition into retirement, as well as gave a plenary on mental health and the new work paradigm, which was quite interesting, very well attended. There was a couple thousand people in that one. I believe this one is available via pre-recorded webinar for those who are not able to attend live. But I believe you have to go through the IFEBP website for that. Daryl and I also did a webinar on emerging trends for 2023 for employee wellness. So we're quite excited about that one. I believe that one is available for download and viewing on the MediKeeper website. Of course, today we're focusing in on the law. This is going to be exciting. Next one up is meeting with a customer of MediKeepers, and that's Vivacity. So we're going to be discussing how they differentiate themselves in the wellness market. And then we're still planning March 2023. Just prior to that, I'll be giving a series for the Work Wellness Institute's annual conference. So this is going to be touching on a few key elements: the future of work, workplace resilience in times of disruption, which arguably we're definitely in right now, inclusivity and workplace and healthy workplaces, as well as disabilities in work. So that'll be a very exciting conversation there. But let's dive into the law. As I mentioned before, it's something that definitely intrigues me, and something that I get an awful lot of questions about from employers and wellness companies, and I refer them on to people like Barbara all the time. Because when you think about it, we have an alphabet soup of legislation that we need to deal with. We've got HIPAA, Health Insurance Portability and Accountability Act. We've got GINA, that's Genetic Information Non-Discrimination Act. We've got ADA, so the Americans with Disabilities Act. Then we have the ADAAA, which is the amendment a few years after that. We've got ERISA, so that's the Employee Retirement Income Security Act. We've got, of course, the ACA, the Affordable Care Act. And then the mother of them all, the EEOC, the Equal Opportunity or Equal Employment Opportunity Commission. So I've signed up for their updates. I've been getting them for years. It's fascinating to see the legislation, or sorry, the prosecution that they summarize. It really helps put things into perspective from a health and productivity perspective. Now we know that this is a topic of interest. We've got a huge number of people who've signed up today. Barbara, how and where do workplace wellness and the law intersect with one another? And can you provide your great insight into that question?
Yeah, well, the clincher, I think, for workplace wellness and the law is when employers offer incentives of some sort, especially to employees to participate in a wellness program, and when they collect employee health data. Certainly from the lawsuits that we have seen in the recent past, the issue has tended to be tension between collecting data from employees and a concern from the employee perspective of privacy. And so when you throw in an incentive to collecting that data, so you offer employees some sort of valuable consideration in exchange for their data, that's where a lot of these legal claims center, is that employees feel like they can't afford to pass up whatever incentive is being offered, whether it's time off or it could be a penalty, off of their paychecks, or it could be a higher premium that they have to pay. The incentive structure, it comes in all kinds of varieties, but as soon as an employer decides that they're going to offer some sort of valuable consideration for that employee's data, which can usually include sensitive health information and, of course, personal information about the employee and or their family members, that's where a lot of employees feel like the employer has crossed the line, and it's what prompts them to file a claim, either with the EEOC, or if it's usually it's with the EEOC, it could be with the state workforce development kind of employer as agency as well. But that's really where a lot of the tension lies, is in that desire by the employer to have information about their employees, and the fear by the employee that the employer is overstepping and invading their privacy. So that's the primary intersection. It's not the only intersection. Some other secondary intersections that I see are when an employer is, there's often misuse of language in employee wellness programming. I've been pounding this whole concept of employee wellness programs under the law really should be voluntary. They should be something that employees, choose to participate in. And then when you throw incentives into the mix, then that whole voluntary nature becomes undermined, especially if it's a very large incentive, or if you're throwing language around like, well, we have a voluntary wellness program, but we require employees to first do this. I've heard that so many times from clients and others who've attended my various speaking engagements. They'll use those two words in the same sentence. It's like, wait a second, you can't say your wellness program is voluntary and then in the same sentence say that, but you require something of the employees, and then it's not voluntary. And especially when that word require is coming from a supervisor or someone in a position of authority, that employee is going to feel like, well, maybe I have to participate in this health fair or this event or this activity or this, whatever it might be. And as soon as you start having employees feel like they're being compelled to do something, then you can invite other legal issues like Fair Labor Standards Act, workers' compensation issues, because those laws really hinge on whether an employee is doing something under the guise of their work, as an employee, as opposed to something outside of work. So if an injury occurs, outside of work, that's not going to be a workers' compensation claim. But if it occurs within the confines of a work activity, then it could be a workers' compensation claim. Likewise, if an employee is doing something that they choose to do on their own outside of work or not feeling compelled, they don't have to get paid to do that activity. But as soon as you start making employees feel like, oh, maybe I do have to participate in this because I could face repercussions if I don't, then you invite questions of, well, should you be paying the employee for their time, minimum wage, overtime, under the Fair Labor Standards Act and the various state-based laws, when they're doing that wellness activity, if it's no longer voluntary. So that's a secondary consideration. Of course, there's also tax considerations, again, leading back to the incentives. Are those incentives taxable or not? Some are, some aren't. And then there's who's delivering the services, the wellness services. Are they qualified? What are the standards that need to be met to minimize legal risk when you're having exercise programs or diet programs or whatever types of wellness activities? And then there's the whole question of, which I'm going to get into, I hope, a little later, of, are you being inclusive in your wellness program? Is there some inadvertent discrimination going on that you may, as an employer or employee wellness program designer, may not even, the intention may not be there, but it may have inadvertent, indirect impact on certain groups, whatever activity you might be promoting through your wellness program. And so being aware of whether there may be some disparate impact and therefore some violation of civil rights laws is also a consideration. So there's a lot of different ways the law and workplace wellness intersect. We tend to just focus mostly on the incentives and, as you mentioned, the EEOC, which is the federal agency that enforces compliance with the Americans with Disabilities Act, and GINA, the Genetic Information Non-Discrimination Act. And I think we focus on that because that's where a lot of the lawsuits and the legal activity in the news has been focused. But I think those other areas are very real risks. And I also think not only are they presenting legal risk, but I think that if you aren't paying attention to what those various laws are really trying to address, I think your wellness program is not going to be as effective. I just, knowing whether you are actually including everybody or making anyone feel like they're left out for various reasons, not really considering some of the root causes of employee well-being. And the laws can help guide you in trying to address those root causes. I just don't think you're going to have as an effective wellness program if your goal is to truly improve employee well-being. If it's just to collect data, that's a whole other issue. But if it's truly to improve employee well-being, I think looking at the legal landscape more comprehensively and understanding why those laws are there can be a very helpful tool.
Yeah, I agree 100%, Barbara. And it's interesting, from my perspective as a non-attorney, watching the EEOC's approach to addressing and pursuing various things, they all seem to come back to your point, to discrimination in one form or another, be it for risk profiling or for existing injuries or illnesses or work disabilities or even non-work disabilities. So we can definitely see the linkage there. Based upon your response, we can say unequivocally that there is an awful lot for folks to consider, whether they be employers or wellness companies or health plans. So based upon your experience, what are the common pitfalls that you see when organizations are looking at reducing the risk, but things may have slipped through with regards to their approach to programming?
Yeah, I think the biggest pitfall is really not knowing where your employees are at, from a attitude or desire for the wellness program. I see a lot of wellness programming, really more of a top-down process where, the leaders of an organization decide, you know what, we need a wellness program and we're going to find a vendor and have them come in and do this. And this is what I think we need to do. We have a lot of employees who look like they're overweight. So let's, do this diet program and this exercise program and throw this incentive to make sure that we get a lot of participation. And they're not really considering how receptive the employees are going to be to that. And that is what really creates the danger of having a backlash and could be in the form of a complaint. Because I've had employees call me, they'll Google workplace wellness and they'll find my law firm and they will think that I'm a resource for the employee. I don't represent employees, but usually when employees call me, they'll start in, as soon as I pick up the phone, I can't even get in a word in. It'll be like 10, 20 minutes later, and they'll finally be able to say, well, I'm really sorry to hear all this, but unfortunately I can't help you. But so I will hear the complaints and just the frustration that employees feel like, I don't want to give my employer my personal information. Isn't this a HIPAA violation? They always go to HIPAA because of HIPAA. We just beat that horse to death. It's just, it doesn't apply in a lot of workplace wellness situations. HIPAA privacy, that is HIPAA privacy and security. But, I do get those calls from employees who've been on the receiving end of a wellness program mandate, and they don't know what to do. They don't want to participate. And it's in those situations where I've come to believe that the employer really didn't do a good job on the front end of understanding the pain points of their employees. And then so I think putting more effort and resources into that upfront planning and getting that buy-in will, I think, go a long way to reducing legal risk.
Okay, excellent. And so that moves us into this concept of, okay, we've defined the problem, we've identified that there is risk associated with the law and the intersection. And can you expand on those solutions that are available to folks with an interest who do want to minimize the risk?
Yeah, well, I mean, the first is to survey your employees, and you can do that, through a number of ways. I don't want to say these are necessary legal solutions, but they reduce legal risk in that you could have a survey of what are the types of things that employees would be willing to participate in, what would they be interested in. Ask them about incentives if you feel like you want to include incentives. Nobody says, by the way, you have to include incentives. They just are something that a lot of employer wellness programs do. Or you could have group groups of employees, representative groups, and have those kinds of discussions. Instead of doing a survey, you could have a group discussion about wellness programming and get employee buy-in from that.
So Barbara, is the intent there to say, essentially, we surveyed our employees, we got the union on board, 95% said X, that they were in support of this sort of thing. We still had 5% that weren't necessarily fully on board with this, but if something were to go sideways down the line, is that a potential defense mechanism to say, hey, listen, we took the time and opportunity to work with management and employees to get to this sort of point? So something like that would offer some credibility and a backstop. Is that what you're saying?
Yes, absolutely. But be wary of unions. I mean, the Chicago case that's currently pending, the city of Chicago, I think it's Williams v. City of Chicago. The employees of Chicago sued the city, and the union eventually dropped out of the case, but the employees felt like the union was not really on the side of the employees, that they were just as guilty of, discrimination and inappropriate wellness programming as the employer. So make sure that the union is actually really representing the interests of the employees. I think that's very important. Yeah, so that's the biggest solution, I think, that employers can implement on the front end before wellness programming starts. Also, I think having a good idea of the legal landscape is a good a solution. I've sat through enough wellness legal sessions and know that if people think if they're in compliance with the HIPAA non-discrimination rules, which has the incentive rules of, no more than 30% of the value of the cost of coverage for your incentive, then they're good to go. They don't have to worry about the law. That's I hope, as I talked for the first question and kind of gave you a sampling of all the different laws that are out there that are implicated in wellness programming, that you familiarize yourself with the legal landscape and keep it in mind as you are in the program design process. And one way you can familiarize yourself with that, a resource that's available, is the Wellness Compliance Institute through the National Wellness Institute now. It offers a self-study course that goes over all of these different laws, and it's a great way to kind of dive in. So if you find yourself in the audience, you're one of those people who are asked about wellness programming, and maybe you're designing a wellness program and you are asked about, is this going to be compliant? Take that course. I think you'll really do yourself a favor in being able to have a little bit more confidence on what all the different aspects are that you need to think about. You're not going to be an expert by any means, but I think you'll know the red flags a lot better.
Excellent. That's good, because we went over that alphabet soup of all the different acronyms that employers and wellness companies are dealing with. There's also, and those are mostly at the federal level, right? There's a whole bunch more at the state level, which would be applicable for multi-state employers or multi-state wellness companies. There's a lot going on there. Now, when you and I were preparing for this session, we had some great conversations, and you mentioned this concept of legal partnerships when it comes to wellness. So I'd like you, to quickly, we only have a few moments here left, is to briefly describe this and how that fits in with this basket of solutions, if you will.
Yes, thank you. And this might be a great topic for another webinar. But when I talk about wellness legal partnerships, I'm using it as a way to get at the root cause of poor well-being. And the concept derives from the medical world. In the medical world, they use medical legal partnerships, which are medical facilities will partner with lawyers, law clinics, legal aid societies. And when a doctor sees a patient and knows that the patient, has a chronic condition, but underlying that chronic condition, they learn that the patient has housing issues or domestic violence issues, or some, more socioeconomic kind of concern, that no matter what kind of treatment the physician might recommend to that patient, if they are continuing to experience these more socioeconomic environmental issues, they're not going to get better. So similar in wellness, you can throw all the diet and exercise programs at employees, but if they are facing these difficulties, environmental, socioeconomic types of difficulties outside of work, or even at the workplace, like microaggressions and discrimination at work, no diet or exercise program is going to work effectively as long as those root causes of poor well-being exist. And so by partnering with law firms or lawyers who can address those root causes, those socioeconomic, behavioral, or environmental issues, you are able to get to higher state of well-being for your employees. And so I'm going to be writing a lot about this over the next year, and hopefully talking a lot about it too, on establishing these wellness legal partnerships through an employee assistance program, an EAP. I think it's a great vehicle that already exists, that we could create these WLPs to address the root causes of employee well-being, so to make that employee wellness programming more effective.
Excellent, thank you. And I agree 100%. This may be great material for a second MediKeeper webinar and really dive into that. So we're up on time. Quick, rapid fire, 3 take-home action steps that the audience can employ to minimize legal risk. Go for it.
Know your participants in your wellness program, familiarize yourself with the wellness laws, and work with a knowledgeable legal partner.
Excellent. Thank you so much, Barbara. Really appreciate your time today. This has been an excellent, very informative session. I'm going to turn it back over to Daryl.
That really was an informative session. I feel it was the fastest 25 minutes we've had all year. It went by so quickly. So I do hope that we do decide to do a second follow-up on this topic. Tyler and Barbara, thank you so much for all your knowledge and information. As a reminder, if you want to go back and listen to the session again, it'll be available on our website in a couple of days. Everyone, have a fantastic day. Thank you for joining us.
Thank you, everyone.